Hi, everyone. My name is Mary Catherine Ricker, and I am Executive Director of the Albert Shanker Institute. Thank you for joining today's Shanker event, the Supreme Court, from Guardian of Rights to Extremist Majority. The Supreme Court of the United States was established as one of three co-equal branches of America's national government. The founders gave the court power for the express purpose of safeguarding the rights and freedom of the American people and protecting against abuses of government power. However, in its most recent set of decisions in 2022, the extremist majority of the Supreme Court has struck down long-standing precedents and long-enduring laws with the elimination of guarantees for many of our rights and freedoms. And most recently, we have all seen the headlines revealing the expanding Clarence Thomas scandal, exposing the ethical questions of this court. Thank you for joining the Shanker Institute today as we welcome Senator Sheldon Whitehouse, AFT President Randi Weingarten, and a distinguished panel as they all discuss the decisions of this court and their impact on abridging America's basic freedoms and what we can do about it. Our first panelist today is Dan McNeil. Dan is the acting general counsel for the American Federation of Teachers. He's been a member of the legal department since 2003 and has also served as AFT's human resources director. Dan provides advice and training to AFT officers and staff, state affiliates, and local unions on all aspects of labor law, including union governance, officer elections, and organizing campaigns. Dan also represents the American Federation of Teachers in matters before federal courts and various state and federal government agencies. Thanks for joining us today, Dan.
Thank you, Mary Catherine, and it's a real pleasure to be here. What I wanted to do was first address some of the cases that are before the court this particular term. And given the right-wing turn that the right turn that the court has taken recently in previous terms, I think it's worth highlighting these cases that are of importance to, one, the continuation of our democratic system of government, as well as those cases that are important to working people. So the court has agreed to hear 60 cases during the 22 term. That's the term that we're in currently in. But before that, I want to mention a case that involves AFT that was slated to be heard for the 2023 term. And that involved the student loan processor service company, Navient. 10 AFT members had sued Navient for their handling of student loans under the Public Service Loan Forgiveness Program. And because of the way that Navient was processing those claims, they were rejected from the program. AFT members sued, and eventually this resulted in a class action settlement. Individuals then challenged the settlement and sought to have the Supreme Court review that settlement. On Monday, we got word that the Supreme Court had denied cert in that case, and this Supreme Court's decision not to hear it clears the path for finally implementing other key aspects of the settlement that will help tens of thousands of Americans access loan forgiveness. One of the things the settlement does is requires Navient to pay $2.25 million to an organization that provides student loan counseling and education to public service workers. So that's good news. Now for the bad news. There are several cases where the Supreme Court is entertaining novel theories that will overthrow long-term precedent and put our democracy at risk. The first case I want to mention is Moore v. Harper. This case arises out of North Carolina, and the dispute dates back to November 2021, when North Carolina's Republican legislature adopted a new voter map. Democratic voters and nonprofits went to court to challenge the map as a partisan gerrymander. The state Supreme Court, which had a 4-3 Democratic majority at the time, agreed that the map violated a provision in the state constitution that guarantees free elections, and it barred the state from using that map in the 2022 elections. After the trial court adopted a new map drawn by 3 court-appointed experts, Republican legislators then went to the Supreme Court. They contend that the state Supreme Court's decision setting aside the map oversteps the authority under the U.S. Constitution's election clause, which provides the time, place, and manner of congressional elections shall be prescribed in each state by the legislature thereof. This is known as the independent state legislature theory. And under this theory, it would say that the state legislature has total control over how elections are conducted, their time, their place, and their manner, and they cannot be reviewed by the state's courts. The lawyer representing the Republican legislators maintained that the election clause vests a state's legislature with the power to make rules for federal elections, and state courts cannot restrict the legislature's substantive discretion to do so. Instead, he argued that states courts can only enforce procedural limits on the legislature's authority. The lawyer for the Democratic voters and nonprofits cautioned the adopting legislators that adopting this independent state legislature theory would invalidate hundreds of state constitutional provisions that give the judicial system, the judicial bodies, the right to supervise and rule on legislative actions that affect elections. This is a very novel theory, not one that we've seen before. And even the court seems skeptical that the independent state legislature theory should be adopted in this case. There has been a development. In the 2022 elections, Republicans did pick up 2 seats on the state Supreme Court, giving them a 5-2 majority. And the state Supreme Court has now agreed to rehear the dispute, which it did on March 14th. Nevertheless, the Republican legislators who brought the challenge to the Supreme Court are asking the Supreme Court to rule, despite the fact that it's being reheard by the North Carolina Supreme Court. The next case I want to talk about is known as Allen v. Milligan. This is the Alabama congressional redistricting case, and it raises a challenge to the Voting Rights Act. In this case, the districts were aligned so that that there was only one district created that would give the Black voters a majority vote. And the voters argued that the state had illegally packed many Black voters into a single district as part of Alabama known as the Black Belt. In that district, nearly 60% of registered voters are Black, but they said the state's new plan dispersed the rest of the Black voters into several other districts, therefore diluting their vote. The effect of the map, instead of having more than one seat that's majority Black voters, one district, the effect of this map minimizes the number of districts in which Black voters can elect their chosen candidates. And they said that the legislature should have created a second majority Black district, and that the state's failure to do so violated Section 2 of the Voting Rights Act. The Voting Rights Act, Section 2, bars election practices that result in a denial or an abridgment of the right to vote based on race. And therefore, that's what's being challenged here. The state is arguing that Section 2 bars discrimination against voters based on race, but that Section 2 does not require an affirmative obligation upon the state to ensure that wherever a majority-minority district can be drawn, that it must be drawn. Instead, the state argues that if the court were to require, if Section 2 were to require that a state create a majority Black district, that itself would violate the Constitution, because that approach would set racial targets and race-based sorting in violation of the 14th and 15th Amendment. The voters argue that Section 2 is one of the most effective prohibitions on discrimination in voting that the Congress has ever enacted. And the challengers in the Biden administration are urging the justices to allow the lower court's ruling to stand, setting aside the Alabama redistricting plan. It should be noted that the Supreme Court is skeptical of the administration and the voters' arguments, and they seem set to do away with Section 2 of the Voting Rights Act. And even a narrow ruling on Section 2, rather than a broad pronouncement, that would make it much more difficult to challenge redistricting plans on the grounds that they weaken the collective voting power of Black people. There are affirmative action cases in front of the court this term. The two cases that have been consolidated are Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina. In 2003, the Supreme Court ruled in Grutter v. Bollinger that the University of Michigan Law School should consider race in its admission process as part of its efforts to assemble a diverse student body. The court is now being asked to overrule Grutter and hold that institutions of higher education cannot use race as a factor in admissions. The question in Harvard case is whether Harvard College is violating Title VI of the Civil Rights Act by penalizing Asian American applicants engaging in racial balancing, overemphasizing race, and rejecting workable race-neutral alternatives. In the North Carolina case, the issue is whether a university can reject a race-neutral alternative, because it would change the composition of the student body without proving that the alternative would cause a dramatic sacrifice in academic quality or the educational benefits of overall student body diversity. I want to highlight a labor case, one that involves unions. This case is Glacier Northwest versus the International Brother of Teamsters. This case concerns whether the Washington Supreme Court properly dismissed a tort action by the employer, Glacier Northwest, a concrete mixing company arising out of a strike by the Teamsters. The company alleged that the Teamsters purposely timed their strike to inflict harm on the company and should be liable for the costs associated with the hardening of cement that was loaded into the mixers before the strike commenced. The state court dismissed the lawsuit, consistent with precedent that holds that the NLRB should go first in assessing whether the National Labor Relations Act protected the strike conduct. This is known as Garmin preemption. And the issue in this case is whether the National Labor Relations Act impliedly preempts a state tort claim against a union for intentionally destroying an employer's property in the course of a labor dispute. It seems likely that the Supreme Court is going to alter the current preemption document, which has stood for decades, and it could have a real chilling effect on workers' rights. If a union has to face a tort claim before going to the NLRB and even figuring out whether it committed an unfair labor practice in the strike, this risk of being assessed damages for that which occurs during a strike, and remember, the purpose of a strike is to put economic coercion on the employer by withholding your labor. That's the purpose, and that's what a strike is. If you faced tort liability because of that, it really chills a union's ability to use this economic means of a strike during a labor dispute. Student loans. In 2022, Biden announced a debt relief program which would forgive up to $220,000 in loans for qualifying borrowers. At that point, student loan repayment had already been on hold for nearly 2 years. In March 2020, Secretary of Education DeVos had suspended repayments and the accrual of interest on federal student loans because of the COVID pandemic. Both DeVos and Biden relied on the HEROES Act, a law passed after the September 11 attacks that gives the Secretary of Education the power to respond to a national emergency by making changes to the student loan program so that borrowers are left not worse off because of the emergency. So in companion cases, Biden versus Nebraska and Department of Education versus Brown, student loan borrowers have challenged, and the states have challenged, whether or not the department's plan is authorized and was adopted in a procedurally proper manner. The states are arguing that the plan exceeds the Secretary of Education's statutory authority and is arbitrary and capricious. This is also a trend in Supreme Court jurisprudence, challenging agency action because the conservative view is that such executive agency action should be limited to what is in the statute. This, again, brings to light a new doctrine that is being used by the justices to rule in the ways that they would like. It's called the major questions doctrine. Now, this was a little known, little used doctrine, but it's now being expanded, and you can hear it in what Chief Justice Roberts said. He said, Justice Roberts was skeptical that the loan forgiveness program was a mere modification of existing student loans. He said, we're talking about $500 billion and 43 million Americans. And so how does that fit under the normal understanding of modifying student loans? So he's saying that because of its economic impact on so many people, it presents a major question. And there's a major question about whether Congress actually authorized the Secretary of Education to forgive these loans. Judge Thomas went even further. He made an unbelievable argument. He stated that, in effect, this is a grant of $400 billion to those student loan borrowers, and only Congress can appropriate money. So he's saying that the Secretary of Education far exceeded its authority because this was, in effect, an appropriation. It sort of strains credulity. But again, the conservative justices want to limit agency authority, whether it be the EPA, the Department of Ed, the Department of Labor. And so using this major questions doctrine, they can limit agency authority because it affects a larger number of people than maybe Congress had intended. These are just some of the cases. I'm going to wrap it up. These are just some of the cases affecting voters and working people. There are several others involving, religious freedom and free speech under the First Amendment. There's a case that was just argued yesterday about a mail carrier who is an evangelical Christian and observes a Sunday Sabbath. The court seems ready to do away with burdens on the employer being an excuse to deny a religious accommodation. And there are several other cases that are before the Supreme Court this term that affect working people and voters and our democracy. With that, I'll turn it back to Mary Catherine.
Thank you so much, Dan. I really appreciate that. It is really clear that there's a lot that the Supreme Court is handling in this session that working people and all Americans should care about. So I appreciate that overview. It is my pleasure now to welcome American Federation of Teachers President Randy Weingarten. Randy is president of the 1.7 million member American Federation of Teachers, which represents teachers, paraprofessionals and school-related personnel, higher education faculty and staff, nurses and other healthcare professionals, local, state, and federal government employees, and early childhood educators. With Randy's leadership, the AFT is dedicated to the belief that every person in America deserves the freedom to thrive, fueled by opportunity, justice, and a voice in our democracy. Prior to her election as AFT president in 2008, Randy taught history and social studies at Clara Barton High School in Brooklyn's Crown Heights neighborhood, where she helped students win several state and national awards debating constitutional issues. Randy also holds degrees from Cornell University's School of Industrial and Labor Relations and the Cardozo School of Law. Randy, welcome, and thank you for joining us today. Before Senator Whitehouse joins us, would you help us set the stage for this important discussion?
I was very appreciative to listen to what Dan was saying. Sorry, when we do Zoom and your other phone rings, you kind of sort of have to take it. I was very, I'm glad that Dan went through some of these cases. I think sometimes the specifics of the cases give you a sense of what's really going on here. And I'm really delighted that Stasha is with us, and Gleneva and Frank and Fred. And Gleneva and Fred, actually, I want to start here, really pushed us, Fred in particular, to, in the aftermath of the end of last session, the court's last session, to really look very carefully at what they did and why, and what we can do about it. And part of having Senator Whitehouse here is because he has been blowing the whistle about this for a long time. And he wrote a book about, he's been outspoken about the rot that has happened because of money and because of cronyism and corruption, and that the Federalist Society and others have had their hand on the scale of justice, and that you see that over the course of the last, and I see Stasha shaking her head, over the last 20 or 30 years. And they have wanted this not to be an impartial body that ignores, does not consider fear or favor, and to actually call balls and strikes, and to really be a Supreme Court that's based upon the rule of law and the principles of our Constitution as we live them every day, not as we live them in the musket society of 200 or 300 years ago. And Senator Whitehouse has written a book, and will be here shortly to give the keynote about the scheme. His book is The Scheme: How the Right Wing Used Dark Money to Capture the Supreme Court. But what I think today is about is very similar to the resolution we passed at our convention, and we talked about at the Executive Council beforehand, which is not simply condemning the decisions of this extremist majority. I mean, the decision, going to be interesting what happens in terms of the abortion pill, but the decision on overturning Roe, which several of these justices, when they were asked that question, said, of course, that's settled law, just like Brown v. Board is settled law. Like, what is settled law? What is the role of precedents? And then all of a sudden, when they have the power, it's no longer settled law. But also the cases around unions, the cases around gun violence, the cases around other ratcheting away our freedoms, and whose freedoms are important and whose freedoms are not. And the kind of ideological lens by which all of this is looked at right now, as opposed to thinking about both values and the Constitution. And so, what part of what we're doing in this seminar is, for me, oh good, I see that Senator Whitehouse has joined. Part of what we're doing in this seminar today is not just to go through the litany of cases, which Dan just did, but really take the next step and say, what is it that we can do about it? And so, and what Senator Whitehouse is going to talk about is, how did this actually really happen? Which I think a lot of people don't know, because they expect that the Supreme Court would go above their ideological views to actually be a court to hold that responsibility in a sacrosanct way to level justice, or to really try to wrestle with what the decision should be for the United States of America in 2023. And I think that the point of what happened to get to this point and what to do now, I think gets punctuated by what just happened in terms of the disclosures about Justice Thomas and Justice Thomas's wife. In any situation other than the Supreme Court, if the wife of somebody who was very, 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 very powerful, who was actually making decisions about the propriety, about the issues surrounding the last election. And the person who that person is married to is actually writing emails or texts to the White House trying to undermine that election. You don't have to be a social studies teacher like I am. You could be just a sentient individual to say that is a conflict. And why is there not an issue about that in terms of the Supreme Court, where there would have been an issue about that everywhere else in the universe, or certainly in the United States? And then on top of that, the disclosures this week about the kind of gifts that Justice Thomas has taken from Harlan Crow and the lack of disclosure about it. So these are real issues about the propriety and the question about whether or not our Supreme Court is the Supreme Court that we need, whether it is the kind of trustworthy institution that was relied on all the way back when the Constitution was written and when Marbury versus Madison was decided. And so, sorry, I gotta show my social studies cred here. And, so that's why I think it's really important, instead of my kind of repeating what Dan had said, to really use this as an introduction to Senator Whitehouse, who has really, as I said before, blown the whistle about this, raised these issues, raised these concerns. And he's done this with Congressman Hank Johnson from the House of Representatives. They've engaged in a series of correspondence with Chief Justice Roberts. They have raised these issues about that conflict of that the Supreme Court should not be above the law. They may make the law, but they should not be above the law. And basic rules around conflicts, basic rules around transparency, disclosure should apply to them as well as to anyone else. And then, separate and apart from the issues of conflict and transparency and accountability, what do we need to do to actually have a court that takes seriously freedom, opportunity, and justice for all? The for all is part of their charge under our Constitution. And so before we get to our Q&A, I'm going to ask Senator Whitehouse, the amazing, remarkable senator from Rhode Island, to really help us. Yep, Frank just is your cheering squad, to help us answer these questions.
We'll be joined by Senator Whitehouse when he is available. In the meantime, it is my pleasure to talk about one of the ways Senator Whitehouse has been championing a Supreme Court that works for all of us. Senator Whitehouse has proposed, and this year has reintroduced, the Supreme Court Ethics, Recusal, and Transparency Act. The SCIRT Act is a comprehensive piece of legislation that would create a much needed process for investigating misconduct at the Supreme Court. It would strengthen recusal standards for judges and disclosure rules for special interests trying to influence the courts. It would improve disclosure of gifts and travel for judges and mandate the creation of a binding code of ethics. The SCIRT Act would also require the Supreme Court to adopt disclosure rules for gifts, travel, and income that are at least as rigorous as ethics rules for members of Congress. As you also heard from President Weingarten, Senator Whitehouse is an outspoken champion for an impartial court, and he discusses that in his book, The Scheme, How the Right Wing Used Dark Money to Capture the Supreme Court.
I think, Mary Catherine, they have called votes. So until the votes are done, Senator Whitehouse is not going to be on. which is why I think what we should do is start actually talking to, I know we have this panel that was going to actually ask questions in terms of Senator Whitehouse, but why don't we actually talk a little bit about all of our perspectives here in terms of this, and just talk amongst ourselves until Senator Whitehouse gets on. We know how to do this. This is what
That's
we would do
right.
as teachers all the time. Instead of waiting, this is what we would do. So,
And it is
there's
an incredible panel. If you'd like me to introduce everyone, Randy,
so
I
why
can
don't,
introduce everyone.
yes, why don't, yes. I like our friend from Crew made it clear that it's pronounced cert, just as in
Thank you.
sorority. So thank you. So why don't you introduce us, and then
Yeah.
I will, talk about, we'll talk about, and I think Fred, why we raised this in the first place, and Gleneva, what your perspective is, and Stasha, get you involved in here as well. I know Frank's the ringer for Rhode Island, but let's get a conversation going here, and if there's questions already, let's do that. And then when Senator Whitehouse gets here, when he gets here, that's what we do as teachers.
That's right. Fantastic. Well, Randy, you are joined today by Frank Flynn, President of the Rhode Island Federation of Teachers and Health Professionals. Frank, thank you for being with us. Fred Cowell, President of United University Professions at SUNY, and Gleneva Dunham, the President of AFT Indiana, as well as the President of the Gary Teachers Union, and Stasha Rhodes, a democracy organizer. So thank you all for joining us today. And as Randy said, each of you brings your own unique and important perspective. Frank, I know that you've had the opportunity to read Senator Whitehouse's book. Would you like to start with a little bit of reflections on that book and on the work you've seen your senator do?
Sure. Thank you, Mary Catherine. First of all, I would recommend this to anyone that's paying attention to current events right now and what's going on with Justice Thomas and the allegations there. Senator Whitehouse does a phenomenal job of, look, here he is. Well, I'll let him speak to that.
Hey, Frank, how are you? Sorry to be running late.
Well,
I had to vote. Hello, Randy.
Hey, Senator.
Important business.
They pay me by the vote, so I had to go vote.
We heard you had to vote, and we were all gonna start opining on how great you were and why all the work you've done is so important. And so you missed all of our glowing comments about you.
Well, nice of you. Nice to have it getting some attention at last.
Exactly. I mean, I remember how frustrated it was when you started this many, many moons ago in terms of raising the issues. And I think, in some ways, not just your book, but Clarence Thomas's actions and Ginny Thomas's actions in the last few years have punctuated the point. But the floor is yours. And what we have done here, and what this what the seminar is about, is that we promised ourselves and promised our members that we were going to take a deep dive into what is really going on in terms of the Supreme Court, and why are we seeing this level of ideological decisions with the thumb on the scale to restrict rights, at least the rights of some people, and what's really going on. And we thought that your book and what you have done over the course of time could help answer that question. And in some ways, we need the answer to that question in order to decide, in order to try to consider what to do about it.
Well, I think in the speech I gave on the Senate floor last night, I talked about the toxic, poisonous cocktail of creepy billionaires, phony front groups, dark money by the millions, amenable justices selected for amenability, and secrecy. Those ingredients are all present in the Harlan Crow, Clarence Thomas sordid relationship, but they're also present in how the Trump list came together so that the supermajority got built. That was done by billionaires in a back room, housed by the Federalist Society, but not done by the Federalist Society. And then they got nominated off that list. Again, I think it was the billionaires and Leonard Leo telling the Trump people who they wanted. So the selection was actually made by secret private interests. And then huge checks, $17 million in one case, were written to provide TV air cover to push for the votes for those nominees. And I can't tell you how much dark money spending went into Mitch McConnell's hands to shore up his Republican senators in order to guarantee that they'd be amenable in the confirmation process. But the big dark money donors behind the Supreme Court capture operation are almost certainly the same big dark money donors behind the Mitch McConnell political spending operation. And then they get on the court after all of that, and you have these flotillas of front groups that turn up that are poorly investigated, don't report fairly who's funding them, and appear in orchestrated chorus on behalf of those same billionaires and tell the anointed justices what it is they expect them to do. And then with appalling statistical regularity, like virtually every single time, the justices do what the front groups told them from their little amicus platform. And all of that is just completely rotten to the core. So this problem of the noxious cocktail of the billionaires and the dark money and the front groups and the amenable justices and the secrecy is pandemic around the court. And I think we need to focus on it very hard. The labor movement has seen really bad decisions come out of this
Really
court,
bad.
where they were actually invited by members of the court and then used very peculiar methods to get to the court. So yeah, it's a real problem. And I think for too long, Democratic groups have seen it as problem 3 or problem 4, that their main issues have always been their main issues. And so the environmental community and the civil rights community and the labor community and the good government community and the women's groups have not coalesced around a common realization that this machine is operating against all of their interests. And whether it's the Dobbs case, or whether it's the labor cases, or whether it's Bruin, pick your poison. It always comes through the court. And it's the place where the billionaires can get done the things that they want done that Republicans in Congress won't do because of the lack of accountability. So it ought to be a really top priority for all of our allies to get after this in a really important way, and in particular to force a little bit more energy on this front from the Biden administration, which has held itself back a lot, particularly that hopeless Supreme Court commission that they put together was unbelievable. Thank God for Lawrence Tribe and Judge Gertner, who wrote their dissenting opinion, which the commission itself wouldn't even publish. They had to do it in a newspaper.
Yeah.
So that's the mess we're facing. I think it can be fixed, but it's going to take a lot of pressure on the court to try to fix itself, and it's going to take a lot of pressure on the Congress to make this a priority. But we can do it, and we must do it. You can't have a court that isn't really a court.
I mean, if you want a democracy, you can't have a court that isn't really a court. I mean, you can't have our democracy.
Yeah. Well, there's a whole separate speech on how they've destroyed democracy.
Right. I mean, it's interesting, and I want to just turn it over to our panelists to ask you questions. But I just got back from Israel, and I wanted to be at the demonstrations, which happen every Saturday night. But what's interesting is that there, the whole issue, again, the same as here, the Kohelet Society is these billionaires from America that understood that they needed to change the court so that, and they're trying that the judicial so-called reform, which is really regime change, is to change the way the justices for the Supreme Court get selected, so that there will never be an impartial selection process again. And so they have a majority on the court, and then the court does whatever that right-wing majority in the court wants to do. And that's the essential change, that the lack of checks and balances, that's the essential change that they want in the Israeli court system. But this is what's interesting. Every week for the last 15 weeks, there have been hundreds of thousands of people on the streets protesting it. And the protests this past Saturday, which was not the biggest, 400,000 people. That's the equivalent of 13 million people in the United States protesting. And it was pretty incredible to listen to have people actually understood how to connect the dots between how this change in the judicial process and the checks and balances would actually destroy democracy. And I think part of what we need to do is we need to actually do that education to connect the dots for people about what has happened here. And your book does a lot of that, and your speeches have done a lot of that. And so let me turn to Frank to ask the first question, and then to Stasha, and then to Fred, and then and you, and then Gleneva, if you have time, Senator Whitehouse. But the other question I want to ask you is, which I think you want to answer, is what is our responsibility as all these other groups that really, really care about having freedom and liberty and justice for all and democracy? Like, what is our responsibility right now? And is it to specifically to alert people to the issue, or is it to also have a solution? Like, what is our responsibility right now?
Well, for a long, long time, we have had a helpless or absent narrative about the Supreme Court, where they didn't talk about it at all, or we'd wait until they did something awful, and we'd have a moment of episodic emoting about how awful it was. And once we were done with our emoting, we'd go back onto other subjects. And we were more or less satisfied with a morally superior, woe is us, how bad this decision is. But we didn't look behind, we didn't pull up the hood and look at what was driving those decisions. We didn't explain to the public how these justices were chosen. We didn't explain to them how weird it is that people are allowed to appear in court at the Supreme Court wearing front group masks without showing who they really are. How weird it is that the Supreme Court would engage in fact finding at all, let alone false fact finding. I mean, you can go through a litany of abuses and show how this court is really out of control, and we have no concerted effort on our side to educate the public about these provable facts. You know, it enjoys the added benefit of being true, is a saying I use a lot. Our case enjoys the added benefit of being true. We just don't bother to make it. And I think now the advocacy groups over a whole different issue arena are beginning to realize we all need to come together and address this problem, because it is being used against all of us. This is a common cause for our advocacy on multiple issues. And there's plenty to be done once we get over that initial hurdle of being organized and propelling a meaningful, pungent narrative. So it's not like we crank up a narrative, get everybody revved up, and then there's nothing you can do. No, there's a lot we can do.
Thank
So
you.
Frank.
Frank, you first, and then Sasha.
Thank you, Senator, for your passionate advocacy on this really important issue, as well as all you do on climate change and so many other things that for the people that you represent. And we really are proud to have you in the U.S. Senate. I was fortunate enough to read your book. It was both fascinating and terrifying. And one of the issues that I'd like to ask you about is you recently led a group of your colleagues from the Appropriations Committee to write a letter to the Subcommittee on Financial Services about conditioning any future Supreme Court funding on the development of those ethics standards. Could you speak a little bit about that and tell us an update?
Yes. So the underlying situation is actually quite a simple one. Every single one of the circuit courts of appeal has its own process for administering the ethics code. There's a place where you can file your complaint. There's a person who's there to read and evaluate the complaint. There are investigators to look into the veracity of the complaint. There's a mechanism for getting a neutral judge to make a decision about whether the complaint is true and that the conduct violates the code. And then there's an outcome at the end. None of that exists at the Supreme Court. It exists in every single one of the other circuit courts of appeal, and they oversee not only themselves and the district courts in doing that. So all the Supreme Court has to do is to agree to set up that administrative mechanism. It has refused to allow investigation of itself. So it's a very simple proposition. And to press them to do that, there are lots of different levers. One is harassing the judicial conference, which I have done, because that animates the other judges who I think are very annoyed. I've spoken to judges who are really frustrated with the shenanigans at the Supreme Court because they know they can't do that themselves. They know there'd be a process that would call them out. They know what the Supreme Court is saying just isn't true. And that adds to the aggravation because they're all feeling the pain of the discredit that the Supreme Court is bringing on the judiciary. So appropriations are another way of bringing pressure on particularly the Chief Justice to finally make the decision to set up an administrative process for considering ethics complaints. And because we have the authority to actually require that by law, not only is it something that the appropriators can threaten to withhold funding unless they do it, we also have the backstop that we can plug as a matter of law, and I have a bill to do that, requirements in on the court. But because I think the best solution would be for the court to police itself, and the quickest solution would be for the court to agree to police itself, that's why I'm trying to put pressure on the court from multiple angles, and one of them is through appropriations. They say that they say they'll never come over and testify to Congress because it, violates separation of powers to be held accountable. When it's their money, they come over.
Thank you, Senator.
And by the
Thank
way,
you.
a word of thumbs up for Chris Van Hollen, who was the chair of that particular subcommittee of the Appropriations Committee, who has been very helpful and supportive in this endeavor.
First, thank you so much, Mary Catherine and the Schenker Institute and AFT, Randy. Thank you for pulling together this incredibly timely and important conversation. I think my head's going to roll off with how much I'm nodding to everyone here. So it's good to be among friends. And I have a question, but I just have to plus one Senator Whitehouse's comment about the need to have a more unified, shared narrative that all of the issue groups plug into in an effort to mobilize people outside of Washington and connect the courts to kitchen table issues that they all care about. And I think that there are a number of conversations to do something of the sort, but I just really think it's one of the most important advocacy fights of our time, and we should all be working together. Senator Whitehouse, you have been a fierce advocate for democracy and an especially important champion for Supreme Court ethics. For obvious reasons, ethics and accountability are at the top of everyone's minds right now. Americans are losing confidence in the Supreme Court. How can we use the moment we're in right now to make progress on ethics and other reforms?
I think that as I said a moment ago, the solution to the immediate ethics problem that the court is facing is within its hands. It's very simple to do. They don't even have to design anything very exotic. They just go to their very own chief judges who sit around the table of the judicial conference every year with the chief and say to them, hey, you guys all do this, what should we do? And it's incredibly easy to set up an inbox for complaints. it's incredibly easy to hire people who will read the complaints and do the investigative steps necessary to assess what the facts actually are. Perfect example, Justice Thomas didn't recuse himself from a case that would have restricted the ability of the January 6th Commission to investigate the insurrection in which his wife was involved. So he was protecting his spouse in his vote and in his participation in that case, arguably. And his defense, which he hasn't had to make, but has been made for him obliquely, is that, oh, I didn't know anything about her activities. Insurrection? My wife? What insurrection? Well, that's a fact question. And what should have happened is that some very polite young staff attorney came in and said, you know, Your Honor, I'm sorry about this, but you've got a complaint about this, and we've got a process. And in the process, I need to take a statement from you to understand what happened. So, like, what did you know and when did you know it? And then you have the statement. And if it turns out that he lied, you've got consequences because it's a false statement and you've documented it. So there are very simple things that they can do setting up this process. It will be very, very consequential. And that's, I think, the immediate goal that we have. Then, of course, we've got to get after the fake front group briefs, which is another question before the judicial conference right now. And then in the long run, I think, you know, we need to have term limits and some control over the politicization of the appointment process.
Thank you.
Thank you, Senator Whitehouse, for joining us. And I do also want to echo Stasha's thanks to Randy Weingarten, Mary Catherine Ricker, and the Schenker Institute for putting this program together. I represent faculty and professional staff at the State University of New York. Obviously, many of us are involved in teaching law and are very, very interested, obviously, in the work that you're doing. I would like to ask a two-part question, Senator. First, as you were just speaking about the Thomas case in general, writ large, there's an audacity and arrogance in his response to the accusations and criticisms that have been raised that remind many of us of the behavior of authoritarianism or an authoritarian leader. When we look at the court and this 6-vote supermajority, they are handing down decisions that are going to affect our lives and the law for decades. How do you encourage us, and also how do you yourself deal with the sense of powerlessness of how do we overcome this institutional power within the court, while at the same time, not only do we need to get groups organized around this issue permanently, how do we get the public, which is so disengaged in political events in general, and lack an awareness, how do we get them focused on the court? So a couple-part question for you there, Senator. Thanks again.
Yeah, I think back to Stasha's point, to the extent that the public is hearing a single message about the court that is coming from across our issues portfolio, then I think we've got a chance to really break through and to make a big difference. I'm a lawyer. And one of the things I learned early on is if you want to go before a judge and get extraordinary relief from that judge, you have to make your case first. You don't get to just waltz into court and say, here are my demands, Your Honor. He'll say, well, why should I give you that? And the public right now is in the why should I give you that mode about the stuff we know needs to be done at the Supreme Court. That's because we haven't done our homework as Democrats, as advocates, at putting that message out there so the public can understand. I sometimes compare it to somebody coming at you with a syringe. And if you haven't been prepared for that, you're going to fight. But if prior to the person coming at you with the syringe, they had sat you down and said, well, here's why you're feeling badly. Here's the illness that you have. We have a medicine that will cure it. I can administer it now. And if you take this shot, you'll feel bad tonight, but within a week, you'll feel better. And, you know, I'm your doctor. Well, then you're busy rolling up your sleeve, not fighting. So we have to get that education piece through first. And then I think because you're from an academic environment, I'll say that we're also need to do some cleanup on aisle 6 about the court decisions that have been rendered, that even if we fix up the court going forward, we still have this legacy of crap decisions that they've rendered. And one of the best tools I think we have to address that precedent legacy is the question of fact finding. So many of their really awful decisions depend upon fact finding by the appellate court, which I think most law professors will tell you is something that an appellate court shouldn't do ever in the first instance. And then they make it worse by finding false facts. Citizens United, all the spending is going to be transparent. But we got $2.6 billion that disproves that false fact, and yet they won't go back and fix it because they had an ulterior motive and they got what they wanted. So we have ways to even do the backward look, and I'm writing a law review article in the Ohio State Law Journal. I want to do good Midwestern place that should be out on how you solve the false fact finding piece. So there's a lot to be done, both in terms of heading off the problem, correcting the immediate problem, and cleaning up the mess on aisle 6.
Thank you.
So good morning. I just want to say it's still morning here in Gary, Indiana. And so I thank the panel for what we're doing this morning. And so as an educator, kindergarten teacher for 31 years, I can just say, really haven't paid much attention to the court until lately, especially with the appointment of Justice Ketanji Brown Jackson. So I began to take notice. And so then I kind of contrast Justice Jackson with Justice Thomas. And so then I believe that I speak for a lot of educators of color, the last rulings of the court, that we can no longer sleep on what's happening with the Supreme Court. So we got to speak out, we got to spread the word. And so I'm happy to be here this morning. And to you, Senator Whitehouse, I just want to talk about working people. So as we go to our jobs and we put in an honest day's work for an honest day's wage, this shocking ethics scandal with Justice Thomas and the billionaires is on all of our mind. And it's just a double standard as we continue to try to produce a day's work, an honest days for a day's pay. And so at the same time, an enormous amount of money seems to be spent on influencing the Supreme Court. So what can we do to encounter this influence without, we don't have that kind of money to fight back. So what can we do as working people?
Yeah, I think the key thing is to call it out. If we try to duplicate it by having an equally corrupt mechanism on the other side that uses creepy billionaires, phony front groups, dark money millions, and amenable justices in secrecy, all we've done is make the country worse. We've got to solve the problem, not multiply the problem. So I think there's a big role in this for people like you who work in public service, because for most everybody who works in public service, there are pretty clear ethics restrictions on what you can and cannot do. In my book, I compare and contrast the way that the public officials who were involved down in the Gulf, giving a pass through the Minerals Management Service of the Department of the Interior to the big drillers offshore, so that when that rig blew up and all those men were killed, there were consequences. And they went back and they looked at those people, and they had received little gifts. They had been given bowl game tickets. They had been given a flight, within the country on an airplane. They had been sent to a skeet shooting tournament or whatever. And they got referred to the Department of Justice for criminal prosecution because that violated the rules for regular executive branch employees. I was on a call the other day and they read a comment from a woman who's a state employee in West Virginia saying that just last week she'd had to report a $5 lunch that she received when she went to give a talk somewhere. And here's a guy who's got a $500,000 free vacation that he was given by a billionaire. And setting up that contrast with what real life is for regular public employees compared to what these guys are getting away with, I think is a really powerful way that people who are subject to those ethics rules can advocate in a very like immediately salient and trenchant way.
All right, thanks. Thank you.
So Senator, I know you have to go, and we're just really grateful for your time. And I think this is the first of several things we're going to do as a union to educate people, educate our members, connect the dots. But also, I think you gave us a really powerful call to action today, which, but I'm mindful for your time. So I wanted to, and I know if you have to split, you have to split. But I wanted to just say thank you for just really educating us today. I think that toxic brew, which we see we see it in elections, we see it in the aftermath of Citizens United.
Yep.
But I think that many of us, I include myself as a lawyer, just putting my lawyer hat on, we're naive enough to think that when you took your oath of office as a lawyer, you would actually look at the law dispassionately. Yes, we all look at it through the lens of who we are, but we are taught that stare decisis, that precedents, that the rule of law, that the constitutional injunctions are really important regardless of what our ideology is. And I think that in modern times, I'm not talking about Plessy versus Ferguson or the other, I'm talking about modern times. I think it's been jarring. You look at the case in Texas against the abortion pill. I think it's been jarring to see this kind of set of false facts creating a premise that creates a decision. It's been jarring to us, or at least, speaking for myself. And I think that you have given us, in terms of this toxic brew, what is really going on here in terms of billionaires, dark money, amenable justices, the front groups, the secrecy, and that it's the same plan as it has been for jerry-rigging the democracy, but just with a different branch. And what I hear from you today is there's long-term and short-term things we can do, but in the short term right now, there has to be some rules of the road here in terms of conflicts. And that is something, and in terms of cronyism and corruption and transparency, and that they're just like everyone else is subject to ethical rules, everyone else in the public service, as you just said to Gleneva, the court that has the most power in the country. These individuals have more power than pretty much anyone else in the country. They should also be at least subject to the most minimal of ethics standards, as opposed to being totally exempt from them. And that is something that we as a union, we as our allies, we can start making that call to action. Did I get that right?
Yep. No, I think you did. The one thing that I'd add to this conversation is that if you set aside Trump for a moment, with all of his flamboyant criminality and misbehavior, he was a extremely high visibility insult to American democracy, and everybody took positions about that, but everybody knew what was going on. It was, he kind of blazed in the sky like a firework. While that was happening and he was doing his damage to democracy, there were also the billionaires quietly tunneling, not wanting to be seen, to degrade the democracy. And in the same way that, if you have a knife wound and cancer, you need to fix the knife wound, but you also need to fix the cancer. Trump was like the knife wound. He was the immediate threat, but the cancer has been really, really, really powerful. And it's behind climate denial, which we're all going to pay a terrible price for. It's behind voter suppression, which is contorting our democracy. It's behind the appearance of dark money in our democracy. It's behind the scheme to capture the court. And it's behind the Republican so-called outside spending, the big money in their politics. And if we don't see that as a common program, then we're not going to understand how to fight it correctly.
Right.
These are tentacles, but they connect back into a common apparatus. And you can't fight against an organized and common apparatus if you don't have an understanding that it is in fact that, and not just random activities by distinct separate groups.
Yeah, that it's very intentional. I mean,
It's very intentional.
I just gave a very similar kind of speech about that in defense of public education a couple of weeks ago. It's very intentional. What they're doing in terms of public education is very intentional. You know, and it starts with what Rufo said, which is to get to universal vouchers, you have to create universal public school distrust. And so you defund the institution, you then, blame it for all the problems of it. You divide people against each other. And then what you see is that the institution starts failing. But it's very intentional. And so I think what I would say, Mary Catherine, to everyone who's listening as we end the hour is that, there are bills that Senator Whitehouse and Congressman Johnson have proposed, bills about this reform, meaning specifically a code of ethics for the Supreme Court. There's a bill to withhold funding from the court until they engage in meaningful ethic reform, and that we, the people who are listening, we have a role to play. We lit up the switchboard. Remember what I said about Israel, 400,000 people on the street this Saturday. We lit up the switchboard with 5 million calls when we were raising objections to Betsy DeVos. The GOP Senate didn't listen to us then, and we saw what a disaster it was to our students. But there are things we can do in terms of raising these issues and creating that pressure. And that is in our middle name. That is part of the AFT's DNA. And we can do that kind of work. And I know Stasha is doing a lot of this work in terms of long-term and short-term reform, which we want to hear about another time, Stasha. But I think as we close today, unless you want to, why don't you talk to us about it? We have 3 minutes, but I want to just make sure that I did that call to action while Senator Whitehouse is here. And so we're going to get engaged, Senator Whitehouse, and we're going to do that kind of work to actually fight for this meaningful ethics reform for the Supreme Court. Sasha, you want to tell us what else we should be doing as we're doing that?
I just want to really reiterate the importance of calling Congress. I think, the Supreme Court is dangerously out of control. Congress has the power to restore order and stop the court from taking away our freedoms. I think there are a lot of smart ideas for making the Supreme Court more accountable and transparent, addressing structural issues and tackling the court's bias and partisanship. The problem isn't a lack of ideas. It's that Senator Whitehouse does not have enough support in Congress. They haven't moved yet. So at this moment, I think the most important thing we can do is call on Congress and tell them to rein in this extreme court.
So with that, what we're going to do, Mary Catherine, is we're going to set that up as an e-activist from the AFT to do some of that work over the next few days. So those who are participating here, let's make sure we have, if you want to, let's make sure we have your email. Give us permission to have your email and we'll put you on the e-activist list. And we will do that within our other channels as well. And I want to just say thank you to Senator Whitehouse. I wanted to say thank you to Stasha Rhodes, to Fred Cowell, to Bleneva Dunham, to Mary Catherine Ricker, and of course to your home team guy, Senator Whitehouse, Frank Flynn.
Flynn.
And to Dan McNeil for this really important discussion about where the Supreme Court is right now, why it's doing what it's doing, and what we can do about it. Thanks, everybody.
Thank you, Randy. Thank you, everyone.
Thanks.
Thank you, Senator. Thank you, Randy.
Thank you all so much. This was really
Thank
great.
you. Thank
Thanks
you,
a lot.
Senator.
Take
Thanks.
care.
Thanks, Mary Catherine.